Okay. Guys, we'll stand up and say the pledge of allegiance while we start our meeting here. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Can I get a motion to approve today's agenda?
I will move to approve today's agenda. I'll second that.
Okay, call for the vote.
Tippit, aye.
Damon,
Wolf, aye.
aye. Okay, the minutes.
I will move to approve the minutes.
Okay,
I would second.
call for a vote on that.
Tippit, aye.
Damon, aye.
Wolf, aye.
Perfect. Ray, no timed items, so if we want to jump around, if you want to do the Alliant deal first, or you want to finish up with that?
Finish up with that. I'd like to take on donated leave first.
Okay,
A couple years ago, we made a number of changes to the handbook, and donated leave was part of that process. Alicia and I have been working on handbook changes, and it's become pretty apparent that this particular provision is really burdensome to the department head and can cost us a lot of money. And I mean, one of the reasons we're here is this change has the potential to save quite a bit of money. Because as it stands, if you have maximized the amount of sick leave you can get, you can turn around and get another 960 hours donated to you. So, you know, potentially you could be out almost a year paid, and that department would, have to pay you, plus they wouldn't have a person to do the job. So we tried to strike a middle ground, or a ground that would at least still recognize that this might be important for people to have and be more reasonable. Because the big difficulty is that if I have somebody sick in my department and somebody else from secondary roads donates their sick leave, I pay that sick leave, not the secondary roads. And if I don't have, if I have to replace that person with temporary help, I can't do it. So this is an attempt to bring this into a little more reasonable amount in terms of available leave. I don't know if there's a right answer, but 960 hours seemed like an excessive amount to me and Alicia. So that's where this is, first issue is coming from.
how many hours?
What?
How many hours now?
You can get 960 hours or 6 months, essentially.
120 days.
120 days donated to you.
So that varies per employee work hour day, but still it's a high amount when we already receive, different situations, they might not have been here that long, but we can max out at 750, 800 hours of sick leave already, and then they're able to get more than what we can even max out at. It's creating this, it just keeps, they get down to 2 weeks and they do it again. I mean, they could go on for, you never know how long, and if they're younger and something happens, and so it's just creating a financial burden on the county as well.
Okay. In plain English, what are you recommending? Just
240 hours for 8-hour workday people, and 225 for 37.5-hour people.
So it goes to 30 days, but then it would be per employment lifetime. So if you have something major, you can do this once, you're out of time with FEMLA. You have to be on FEMLA to receive this anyways, but, and then say something happens, you do this, and then 10 years later you're in a car accident. The department head can obviously override that and let you get donated time again. But it's just try and keep it from the snowball effect of, like Ray said, it's coming from a different department, now he's paying it, and he's still paying his employee, but yet he's not getting work done. He's having to either replace, and then you're doing budget amendments, or
You guys understand what's going on, or you're still all fuzzy?
Yeah, I understand what's going on, and then I definitely understand the the financial burden. You know, especially when you don't have that in your budget. Thinking.
So you're doing away with the donated time?
No,
No.
just,
You're just gonna cap it
we're
at,
gonna cap it at 240 and 225. So cap it essentially for a 40-hour person, 6 weeks instead of 6 months, essentially.
okay,
Now, is that a one-time, lifetime thing, or is that per year?
It would be a lifetime unless the department head intervened and authorized additional. Because right now, it's as many times as you want.
yeah.
Pretty much, yeah.
So they could come back to work for a few months, all the conditions reoccurred, I could get more donated sick. And it could go on endlessly.
Somebody must.
I don't want to be heartless, but 6 months in the top of all your earned leave, that's a lot.
Especially if somebody like is a new hire. I mean, so.
And we increased all the vacation, I mean, the amount of PTO that employees already did receive. Like I said, I know it varies if they've been here and haven't been here very long when this happens.
And this cap is just what we came up with, it's not set in stone. If you think something else is more fair or more appropriate.
I think something needed to be done,
I agree with you.
because if we're, and kudos to everybody who's willing to donate their sick time, because they then won't have it if they need it. And I think it's awesome that people are willing to do that, but if you don't need sick time and we don't have to pay it, then that's just money we haven't spent. Whereas if you donate it, it's being spent.
Yeah, it's not paid out when
Yeah.
you leave, so.
So that's a big old matzo ball hanging out there.
So then if those other employees go in the gap, they might be paid overtime or comp time and, yeah.
And you still have to cover the shift. So, yeah, this is definitely needed.
My thought is, should we have our elected officials and department heads look at this and see if they believe this is workable for their people?
We did that, that's how we got to where we were last time, having a
Okay.
huge committee that,
Yep.
you know, I just think you need to make a decision whether you like it or not. If you don't like it, then we'll go back.
And I think there was a department head involved in this already. Because it's affected
The
them.
sheriff and I have talked about it. He's very much in favor. In fact, he favors no donated sick leave.
I've worked in places that allow it, but it's usually like a day or two here and there. I've never seen it to this extent. That's
I
a
know
lot.
one county that we had talked to some time ago, they had call it a countywide bank. If you wanted to donate some time, it would go in this bank, and if somebody needed it, they could use it out of there. But I don't know if they had a cap on how many hours they could use or anything like that.
There used to be caps on how much could be donated too. Like, I don't remember what it changed a couple times on the vacation, how much you could donate to that or the sick leave. And now there's no cap on how much you can donate even. It's just how much they can receive.
But there's no numbers in here.
No.
That's what I mean. I can donate as much as I want, but they can only receive, 960 hours if they're 8-hour employees. Where it used to be like 20 hours of sick leave. I don't remember the exact numbers, but
But what I'm getting at is that you want to change it to 250, right?
240.
From 9,
40, 30 days.
Yeah.
okay?
Yeah, it's
You don't
not-
have it, it's not
It's
in
not in
writing.
print here.
It's in 30 days. It says, so program requirements D, I just changed 120 days to 30 days, which equals, because it's based on your normal work day.
Okay.
So
That's where if they work 7.5 hours versus 8.
Yeah.
Okay,
So
you're going by the
Instead of
days,
putting all
not
the
hours.
numbers,
Yeah.
yeah.
I'm sorry,
It just calculated out.
we started talking hours, I think we ended the days.
Okay, got it, understand.
I mean, 30 days is still generous.
And they can still use the, FMLA.
Yeah, so they have to be on FEMLA in order to qualify for this
to get to
and
receive this.
be down to 2 weeks of their own paid time first,
Okay.
before they get any donated time. So I mean, they've already, when they come to this part, you know, it again varies how long they've already been off. But FEMLA, they get up to 12 weeks in a year. But they use their time first.
So even after they get the donated 30 out for 30 days or whatever, they would still, their job would still be held as long as FEMLA department. They just wouldn't have the paid time off after that.
And each states that if I give up 10 hours of sick leave and all of a sudden I need it, I don't have it,
No.
it's gone.
It's
Right,
not, yeah, it
it's
says, all unused leave is forfeited.
Once you cough it up, it's
Even
you don't
if
get it
that
back if they didn't
individual
use it,
doesn't
or-
use it, you've already given it.
it's
So.
done, it's not available for you. Very good.
It's gone, it's gone.
Well, then with, you know, like the 120 days, from a payroll standpoint, say they were to get that much, and then come someday they quit, retire, how do I determine which hours were donated and which weren't to pay them out? Whether, you know, if it was vacation that they get paid out, how do I, you know, go back and determine all that? Or somebody new comes in to do payroll and, you know, they wouldn't know that.
Yeah,
The
you would
record
know,
keeping of it all.
you would know at that point they've used all theirs and this 120 hours, or 240 hours is definitely donated time. Once they've used all
But then they hit their
theirs.
anniversary and get their own vacation, but all that's on the books. So how do I,
And you
what do
wouldn't
I pay them out
for
if they quit the
accruals.
next day?
Yep. Once they're back to work from, I understand that.
I did tell Haley we have our leave codes in our system. And right now we just add it, whether they got vacation, sick leave, donated. I want to do an actual donated leave pay code,
That
leave
shows
code,
up.
so then it's all separate. So then it would be easier to keep track if it gets paid or not, if they were to leave or something.
So you can donate vacation now?
Yeah, right now you can donate vacation, personal days, which would be by the day, and sick hours. I think the only thing is comp is a
And
different.
we're trading hour for hour.
Sorry,
If
what's
you're
It's on
gonna,
an hourly basis, yeah.
it's on an hourly basis.
Yeah.
Okay.
I mean, personal days have to be donated by the day, so 8 or 7.5 hours, but.
You two understand it?
I understand it.
Okay, can I get a motion either to approve or disapprove resolution 2626, the minute resolution?
I would move to approve resolution 2626, which is amending resolution 2522-25.
I'll second that motion.
Okay, call for a vote.
Tippit, aye.
Seaman, aye.
Bullseye.
Will we make this go into effect at the end, like the start of the new pay period, or
Yeah.
can we maybe make that in the motion, make it when it's effective?
Okay,
I would amend my motion to have this resolution become effective the beginning of the next pay period.
Which will be Saturday.
This coming Saturday. So it'll be April 18th.
April 18th, second.
okay, call for a vote on the amendment.
Tippit, aye.
Seaman, aye.
Bullseye.
Okay, the next issue is also aimed at cost saving for the county. It is a resolution to approve a return to work policy. Our insurer has really pushed for this. It applies not only to workers' comp injuries, but it also applies to non-work related injuries, but it's primarily targeting workers' comp injuries, because right now, we don't have anything that requires them to return to work on a transitional basis, so they can sit at home and collect, depending on whether they can do a different job, whatever. So this, one thing this policy does, it puts in deadlines and procedures. If you're injured, once your injury is established, once you have it, then we send that, under the policy, we would send an evaluation form to the doctor along with the job description, so they could provide us a letter saying, yes, they can or can't, or they can do the job with these changes, or they could maybe do this other job. If we can accommodate that, then we would send them essentially an offer letter for this other job pending their full recovery. While they're out on leave, they would have to contact their department head once a week for updates, and we would require medical evaluations every 30 days or at each doctor appointment, whichever occurs more frequently. Because right now, we don't have any deadlines when you have to update us. We don't have any requirement that you stay in touch with your department head on a regular basis. The policy defines the different types of leave, disability, temporary total, temporary partial, and median period leave. So based on which one you have, it kind of triggers what opportunities or options are available to both the employee and the county. But the insurance company will want this because they want to see people getting back to work in some capacity as soon as they can. So that's the purpose of this policy.
And again, it saves the burden on the other employees filling the gaps too, and pay over with the overtime. Or filling shifts, etc.
On the insurance pool, Benton County is the only county that does not have this type of a program. We're the only, and we know where we sit on the workman's comp ladder.
Because some of them, with that supplemental, they get more
They make more.
on workman's comp than they would on a normal paycheck.
Take home's more sitting at home when they could be doing something.
Yep.
I also like the writing in here where if they refuse to come back to work, they don't get paid anymore.
Right.
I like that wording. I like that a lot.
Yeah, the form for if they want to supplement their work comp benefits, that was taken from Cedar County, I believe, that Judy had given me. They don't supplement automatically. These employees would have to use their own time to receive their full paycheck, otherwise they're just getting the work comp benefit, which is like 80% of their past 13 weeks average. Right now, the county just supplements and so they receive their full paycheck. So, and work comp pays weekly and we pay bi-weekly, so I have to hold on to the checks until I can take them out of their net pay because of all the deductions, health insurance, that stuff.
Can you clarify this strictly with injuries, not illness for a set period of days?
Right.
Yeah,
Injury
so-
only.
Yep, this
A
is
work
work comp
injury.
injury, or on job and then off job is a little less detailed, but like we have these forms
Okay.
to send
That's
out,
what
you
it's
know,
on
what
here.
can they do that, you know, you're not bringing back too soon.
Yep.
That they're gonna now create a work comp claim, but
Well, the big advantage is we're gonna actually have more information about our employees, you know, injury situation, because now we aren't getting this kind of updating. You know, so we're gonna step up the game, I think.
So we've also had concerns, like, you know, another department head was emailing out, does anybody have any work for the so-and-so to fill the gap for them? But if you want to address anything on that, Liz?
Well,
Like light duty,
we can,
like if, like say my office during election, okay, yeah, somebody can come and stuff that, you know, if they're not able to go physically do something, they could sit at a desk and stuff envelopes or something like that.
yeah, I mean, I don't see anything wrong with reaching out to all the department heads and saying, do you have something this person can do? Years ago, my dad was the weed commissioner here in Benton County, and, winter you can't cut weeds, he would come in and said, just piddling, he would come in and help the janitors in the courthouse by polishing brass and everything else. So we need to get back to that, I think.
So in that situation, though, say it was a secondary road employee, those wages would still come out of secondary roads even if they were in my office doing something.
Right.
Okay.
So where does it state in here about us picking up the difference between workman's comp and the regular wages? Is that,
It would be the supplemental part.
Letter L, 4.
Employees will receive pay directly from Benton County insurer. Employees have the option to supplement their pay by using their paid time off. See
Okay.
attached form.
very good, thank you.
Was the mileage always in there? Reimbursement to and from their.
They have always been able to. I did have one recently, and she just asked if they used their forms, so I put that in there. That they can, they
So I
have to
wonder
use creative risk form, but they have to either turn it in directly to their work comp case manager, or I can submit it for them.
Do you think we should put something in there at the current rate for mileage?
It is in there.
Well, they figure that out,
Okay.
the work comp. I just send it to them, I don't do anything with
Okay,
it.
so they do that, so we
Yeah.
wouldn't have to.
Yeah.
Because you know how that changes your rate.
Right.
Right.
I agree, this is definitely needed.
Costing us a lot of money to not have it.
Just one thing we probably should have added, if you were to not do the supplementing anymore, how that would work for their benefits.
That they have to pay their premium,
Yeah,
because we paid the health insurance a month prior,
Oh,
so that is a good point.
that's why when I do take the work comp checks out of what we pay, I have to do it off the net instead of the gross, so that's all taken out, but
And that would, same would go with the
third.
donated leave, if somebody was out on medical too, if they're still on FEMLA, they would have to pay their premium share.
I know it's a lot to throw at you, but it's really something we need.
It seems like we've had a cluster of these issues come up lately, so we want guidance for sure.
You're gonna make our insurance happy.
Yes, that's always good.
Yeah.
no,
Judy was at the last safety meeting and we talked about it a little bit. So she had set an example that Ray took this from, and I just kind of added the non-work related injuries, just to kind of have it separated.
I visited with Judy quite a bit about it as well, off and on the last year.
Would it be smart to send it back to you, Ray, and add that in somewhere on the insurance? So it's in black and white.
Yeah, I think so. I
Yeah,
should have thought of that, sorry.
Maybe
Yeah.
put it in,
Put it in with that pay.
do we need to put it in the other, donated leave one too, if they're on?
Well, that I believe is in the FEMLA.
That's
policy.
covered under FEMLA, so, but I do, yeah, I think
And that's
that
when
this
they're-
needs to, so that those employees are aware that if they're unpaid or didn't accept, that they're responsible for their premium.
Just their portion.
That's my opinion. It should be in writing.
Okay.
That's the only thing I would add.
Yeah.
Go ahead.
Oh, I said, you can still approve it today, you can just be like, so long as this is added
It
in.
changes.
Right, that's what.
Yeah, I'm gonna take up more time doing that.
No, yeah, so like you can just put in your motion what you want
Put it
added.
with this addition,
And when it's gonna go into effect again too.
yeah, and I
Because I assume those that are already on it,
Not gonna have the benefit of it.
they'll be grandfathered.
So
The old
if we could
way.
put it into place, say similar to the 18th again, start a new pay period.
But that won't affect the ones that are,
Right,
I don't feel you can.
right. You can't change the terms.
We can't go
of their-
back, because they didn't agree or know this was.
They weren't, they weren't told that this is the situation they're gonna be facing. So now, when we're done, we need to publish this to department heads, along with the other policy too, to make sure they distribute it to their employees, or just do all users countywide and send it out.
Or a payroll stuffer.
Yeah, something like
Yeah,
that.
I had an employee ask because they, what if we don't have internet, because we have it on the website, the handbook and stuff, but, so I thought about getting all these changes, if we do them in there, get it all actually corrected, update the effective date, and then ask departments. Because not everybody has emails either, out like at roads and stuff, I don't have everybody's email. Just say, can you get a list of how many hard copies you need, and we'll just print them off, so
why not just print one copy and give it to the department head, because every one of the employees ends up around the department head's desk, and they can ask to read it.
sometime.
Yeah.
You got the maintainers out.
Well,
I just don't want anybody to say, well, I didn't know about it, so I just,
And I think this is something we can reiterate at our all-employee meeting.
Yeah, we're gonna go over it the employee meeting for sure,
Yeah,
both these policies. changes.
If you want something, we can have them say, read and signed it, read and have
So
them
that we
sign it.
know that they did too.
That'd be my preference. They should say they read it.
Well, this particular one, doesn't it have a signed one on
Does it?
it? Yeah. Well,
No, if you got the
it just
form
says
on
a
it.
form.
we
but I
have the
think
handbook one.
The handbook one, if they sign
It's at
the
the end of
revision, then we have a copy on file.
Because we added the safety footwear policy in there.
And
That could actually be up to the heads of the departments again too. If they have a department meeting,
Right,
it'll be up to them,
Pass
heads of
them
the
up.
department, to make their employees sign it.
And we had that brought to our attention today too, so I think we need to go back to that footwear. It says up to $150,
Huh?
but it doesn't say is that one pair or what, can they get two pair under the 150 and still get their amount?
well, on top of $150 used towards football.
But it's not
Yeah,
they use it.
specified in there.
It was talked
so-
about, but it wasn't specified at just one pair, so this person had got two pairs, like tennis shoe ones, and it was changed and he didn't get his full 150.
Then they got paid for the one pair. So, but what if somebody went out and bought a more expensive pair, then it's,
They're
they're
still
gonna
getting
be like, well,
150.
that's not fair, they got more towards theirs than what I did, so.
Okay.
Always something, trust me, we
Oh,
hear all about it.
My thought is, you get $150 for the user, and it's up to you.
Yeah.
That's my thought.
If you wear an $80 pair of shoes and the next guy buys some for $150, you get the 80, they get the 150, that was your choice.
Yeah, that's my attitude.
I
I think the
agree with
policy
that.
fits that.
That's the way I understood it.
So just leave it as one pair
Yeah, you have up to $150 to spend.
or
If you
one
spend
pair?
more than 150,
You only
you get 150.
It's out of your pocket.
But that's what I'm saying, he didn't get 150, he only got however much the one pair was. It was on the same receipt,
And we appreciate the fact he saves money.
Yeah.
but it didn't say one pair, it says
Right,
150 for footwear.
we might need to just specify that, one pair.
We're gonna,
I mean, I don't really care if we get two pairs, if we just get
yeah, I don't care, they
150.
get 150, yeah.
No.
We've got some lesser changes that we've been discussing in the handbook. When we come back with those, we can, insert that wording, a pair.
Okay.
But these two, I think, are important, that we didn't want to wait until we got the complete, list of the other changes. And none of the changes we're talking about are significant, we're just kind of cleaning things up.
Again, the wording,
Yeah.
one person interprets it this way, another interprets it this way, just clean it up so everybody's on the same page and making my job
Everything's
easier.
handled the same.
Alicia,
Every department's handled the same this way.
Yeah,
she's done an excellent job of bringing structure to a lot of these issues, and I'm really grateful she's helping with some of this, because it's daunting.
Okay, getting back to the return to work policy. And let's,
Resolution.
yeah.
26.
Looks like 26, 27, adopt the Benton County return to work policy. Can I get a motion to either approve or disapprove a resolution?
Approve with that one change.
And then.
Yeah,
it's
then
back-
add that in.
Yep, just do that in a motion.
I would make a motion to approve resolution 26-27, adopting a return to work policy with the addition of the wording as it was discussed,
And effective April 18th.
effective April 18th.
I will second that.
Call for vote.
Tippit, aye.
David, aye.
Bull's eye.
All right, let's turn to the power plant. As you know, I've done some research. And our intern, Greg, has really been helpful too. It's really something. What we're looking at is a proposed power plant with a natural gas pipeline to support it. These projects are regulated by the Iowa Utilities Commission. And it's an administrative process. So to understand when an application is filed with the Utilities Commission, then affected parties like adjoining landowners are given notice. And then once you get that notice, you have opportunity to file as an intervener. You have to meet certain criteria to intervene. In legal terms, you have to have standing, which means you have to be directly affected by the proposed project. So the Iowa Utilities Commission, once they receive the application, do the notices, accept or deny intervention request, then the discovery process begins where they send out to all the parties, the application, the attached reports. If you file resistance, then the other parties get it. And it's just like in a criminal case, essentially, to ensure everybody has all the information about what is being proposed and how it is expected to play out. So once the discovery process is completed, then there will be an administrative hearing in front of an administrative law judge. And these can last quite some time. I mean, there's a lot of people involved, you're talking days or week, even 2 weeks. The administrative law judge will then issue a ruling approving or denying the project, and then those parties who don't agree could go to district court and try to get the court to reverse or amend the findings. The standard, when I say standard, I mean what the law says they have to show, and the Iowa Utilities Commission will have to decide if this meets the convenience and necessity of the public. So this convenience and necessity standard essentially is a balancing test whether the benefits outweigh the harms, to put it really simply, and I'm really simplifying that. So they will make this balancing decision, this decision on this business balancing test. The courts have interpreted that their job is not to second guess the balancing that they go through and the conclusion they reach. Their job is to determine if the commission followed the proper legal steps. So in legal terms, great deference is granted to the Iowa Utilities Commission on these issues. They're not going to second guess it unless there's a constitutional issue that arises, and those are always reviewed de novo or in whole or in totality. So this battle really has to be at the Utilities Commission level. That's your best shot at fighting this thing. Now, different people have different interests, and that's going to play into this quite a bit because the adjoining landowners have strong claims. They're affected most directly. The effects on their land, their air quality, water potentially. So they have, in that sense, the greatest, or as good as anybody, argument to intervene at the IUC level and fight this. Second to that is Atkins is on a good footing to fight this, but they've got to do it. They're directly affected by the offset in the ordinance that Lynn County passed at 1.9 miles, because they are what's called a residential zoning area. So, and that ordinance targets residential zoning areas in its offset. So they've got a good argument. The counter argument is going to be that, well, that ordinance only applies to within our county. Tried to research to see if there's overlap with counties affecting counties, and there doesn't seem to be anything out there on the issue. So I think it's a fresh area for Atkins to challenge this thing. Our situation is much more difficult because we have to have standing, Benton County has to have an interest specific to Benton County. So while it might affect the air quality of the three neighbors, that's not Benton County. We don't own that land. We don't have the right, we have the right to control the types of land, but we don't have the right to control, those sort of things.
To clarify, it's like legal interest.
Yes.
Of course, we have interest with the public,
Right.
but we're talking legal interest,
Yeah.
what separates everyone from
Yeah.
just like when we talk about cities and stuff. Cities are like separate, obviously, from us. They have a separate code section. It's no different, like say, a government entity from a private landowner or a private individual. Legal interest versus public interest. Make that difference. It's Benton County. What legal interest can you?
And let me say, I'm opposed to this project. I would like to see nothing more than to have it fail. But I have to advise the county on what they can do. And the best arguments lie with these adjoining property owners in Atkins. If there were potentially some conservation area that might be affected, the problem with that is, and I'll get into this more in a bit, is that just to say it might be affected is not enough. You can't, and we all know there are bad effects from this, but that's not enough. So the interest that the county does have, though, is in infrastructure and roads. And 32nd Avenue or the Benton-Lynn line is a boundary road. Currently, there's a 28-day agreement in place with Lynn County, and it just so happens we, under the agreement, are responsible from Highway 30 south on the Lynn-Benton Road. So we control that. That's our road, essentially, under the agreement. I talked to Myron. I said, Myron, what kind of effects are we going to have if this thing goes through? He said, well, the daily traffic isn't really the concern. He said, the concern is the construction traffic. It's really going to tear this road up. And I said, well, let's say that if the project's approved, will Lynn County, since they've sort of caused this thing to happen, will they take the road back? Will they, because Lynn County, they maintain Lynn-Benton Road going north from Highway 30. No, we have it south, they have it north.
Oh, okay.
We have it south, and the power plant's right south of the.
Okay.
So, he was gonna talk to his counterpart and see if worst case scenario happens, if they would take that back and give us the north half, so we wouldn't have to pay for the cost of that, maintenance from the construction traffic. In addition to the things I've discussed, what's probably even a bigger concern is the natural gas pipeline it's going to take to feed this facility. There's several cases in the Supreme Court. One is Putney versus the Dakota Access Pipeline, which really, really covers this whole scenario very thoroughly. And what it says is that eminent domain can be used to take land to run this pipeline, and that, of course, it comes down to this determination of convenience and necessity. But in the Dakota Access Pipeline, North Dakota had oil fields that just, were producing like crazy. and they couldn't get the oil transported. So they wanted to build this pipeline from North Dakota to Illinois. They went through, I think, like 29 Iowa counties, or wanted to go through 29 Iowa counties. And a lot of people fought this. They really dug in and fought hard. And the Supreme Court ended up allowing the pipeline, saying landowners don't have the right to prevent the taking of their land, which I have a hard time with, but they are entitled to have some say in what they're paid for it. But it had, the thing that's, I think, maybe gonna help in this situation is it has to be for a public use or benefit of public use. This project appears to be solely for the benefit of Google, not public infrastructure or things of that nature. So when it comes time for the IUC hearing, that will be the argument, that this doesn't benefit the public in the way that the statute requires. The other thing is that the court said if landowners can come in and propose an alternative route that's less invasive, then they have to follow it. So, along with the Dakota Access, there's the carbon pipeline cases, and they're all pretty consistent that if these things meet the public convenience necessity standard, then they're got a strong likelihood of being passed. And I looked up, because to me, convenience and necessary is pretty broad. And what does that mean? The Supreme Court said in this Putney case that necessity does not mean absolute necessity. It doesn't mean that. They didn't go any farther than that, but you don't have to make it, it doesn't have to be absolutely have to have it to be able to build it. So that's kind of a summary, and Derek might want to jump in here, but as Benton County, if we intervene, it has to be on something that directly affects Benton County, not its residents. It has to affect the county.
Legal interest.
Legal, and that's what I'm talking about here, legal interest. Everybody agrees this is a bad project. Everybody agrees we don't want it. Everybody agrees we need to fight it. But we have to we're legally where we stand, and it's going to be tough. It is, and
If we jumped in, it would be. And I like last time when we had these conversations, private landowners have options that we don't.
they do. And they might benefit from pooling the resources and get an environmental law attorney who's done this before,
Because we only have a small box that we've been working through, especially constitutional wise. And also what the statutes of Iowa allow us to do. And so that's where it makes it difficult. Whereas, like, say, private, you have the whole Constitution open to you, and whatever option is there, because the whole point of the Constitution is the relationship with the government and people. Same thing with the government.
Question, the 2.5 mile
Mhm.
ordinance, is that a Cedar Rapids or is that a county?
That's a county.
That's a Lynn County.
So could we adopt something that says 3 miles and have it on our books, and then Atkins go and do something on their own as well?
So here's the thing with that. If we pass an ordinance, we're essentially opening up the door for someone to come in
Come
and
in and
apply.
say,
And then you have to then go by those rules. Because you can't just be like, nope, we're just doing this to defeat, we're doing, it's almost a discriminatory use, and you can throw that.
so our current 70 CSR really helps us more than if we were to adopt this ordinance.
Correct.
Actually, this 90 CSR argument, because that's what the land is a really strong one. It will carry some weight. I don't know if it will be a deciding factor in the IUC hearing, but the need to preserve agricultural ground, and this is some of the best ground maybe in the world, certainly the United States.
I agree.
Yeah, so I think that's a powerful argument that certainly will be asserted.
And it's tough because our jurisdictional line, it's right on the other side. And I've heard people where they grew up, say like in Jasper County and Polk County, decided to landfill right on the border. So, and the wind just blew everything into Jasper County. It's just something that sucks, is like, cause nothing we can do against another county, we can't find anything, and it makes sense, why, because, we're supposed to be agents of state government.
If this was in Benton County, we could stop it with our land use ordinance. We could. And that's why it's not in Benton
I
County.
was gonna say, that's exactly why we don't have that.
Right.
So in the future, if legislative would pass something, they would supersede our ordinance, though, wouldn't they?
Oh,
Yeah.
yeah, then that means we would have, it'd be preempted is
Yeah.
the legal term, and then we'd have to go back and
And revise.
fix it.
But at this time, nothing is at that level.
Yeah.
So.
And cause like, and I'm gonna be honest, I know I said this last meeting, like, we might not have a whole lot of options, just because of how we're classified
On the legal side.
on the legal side.
So here's the plan. We wait for the application to be filed in the Iowa Utilities Commission, and then because until we know exactly what their plan is and what their supporting factors are, you can't really develop a strategy anyway. But once we get the application, we'll look for ways to intervene, and when we can, we'll intervene and file our objections, and make sure we're part of the process, and go from there.
And I know City of Atkins, because Scott sent out a letter, which you guys had, and that's a very well-written letter, and I think it really lays out like great issues that you guys are facing.
Yeah, just full disclosure, I'm a member of the city council, Jeremy Rolando is a member of the city council here today. We're not here to represent the city, we're interested in raising comments today, as well as various people in the room. The only thing with the county not being able to help us out a whole lot, because it's more of a other issue. Since that's within our fire district, and we have
Yes.
sole responsibility going into that fire district, into Lynn County, does that give us any more leverage from the county attorney aspect?
Well, I guess here's our thing, we don't really have a countywide fire department per se, or like EMS. And so that's where, because like, that's something that you guys specifically budget for, you guys
Well,
specifically.
back to the budget, we'll be coming back to the EMS budget, because we're gonna have, who knows what dropped on us to support that facility. Obviously, we're not gonna go put out a natural gas fire. It's not gonna happen from Atkins, right? That's gonna be running until they get it shut off if they have an event there. However, there's gonna be as you're all familiar with, unmandated
Right.
requests, and they're gonna dump that on Atkins. And we're gonna
Our fire-
get your EMS fund as hard as we possibly can.
You guys are volunteers.
Yeah.
I mean, you're asking a volunteer to go into that situation, whereas in Cedar Rapids, if it's.
The Alliant people have told us, and they've mentioned at meetings that a lot of us have all attended, that will be under the responsibility of the Atkins Fire District, EMS and fire support.
In this Bundy case, they talk about effects on infrastructure, which is what you're talking about.
Right.
That factor, the CSR factor, these are all things that in this hearing should be, given some weight by the Iowa Utilities Commission. So, Atkins may want to consider putting together, some sort of documentation to show how it would affect them, or how they would not be able to meet, the necessary fire protection requirements that this will set.
And Alliant, in respect to that though, Alliant hasn't reached out to us as much as they've received the supervisors getting those emails. They haven't told us a whole lot of anything, and I think it's because that the letter hasn't gone out with the notification. And hopefully somewhere down the road, we reached out to them, Scott's reached out to them 2 or 3 times, and they have not yet to come forward to us with any type of information. Specifically, I know about the fire department, what kind of constraints that's gonna cause us. And then we're gonna in turn go to the county for the EMS budget to fund those requests. And back to the 2.5 mile buffer, or whatever the buffer is, it's really funny. I wish the supervisors would do it for the entire county, come up with a buffer until the state takes a hold of this program, just like they did the CAFOs 20, 30 years ago, in respect to where those were landing around, the state getting interest and create a buffer, so you don't have to do this all the time in case somebody wants to build a landfill in between Palo and Atkins on Lynn Benton Road. The farmers are all pretty good there. That's traditional farmland. Everybody has, generational farms, but you're talking generational wealth there too, and it's very easy to sell that property. And if Lynn County's gonna do that, and it's probably gonna happen, it's gonna happen somewhere else around here. It's gonna happen south of Belle Plaine. It's gonna happen down to Walford as they track down Lynn Benton Road with the 160 acres plus. Or it's gonna hit Urbana or Shellsburg. I mean, there's a lot of us there. I really wish you'd consider putting the buffer up. And if somebody says, oh, the buffer's there now, we'll build just outside of that, well, that's fine. Benton County Planning and Zoning can take that forward and the supervisors can talk about it at that time. But I don't think this is really a good idea in interest Atkins, who doesn't have endless deep pockets to take on Alliant lawyers to get this stopped. We can only do so much. And I understand your guys' role and I respect that, but we're gonna be put in a situation where it's David versus Goliath. We can take them on and we can get the media, and the Scheer family can show up with 10,000 signatures on petitions, but it's still gonna probably happen. And we're not gonna be able to build to the south because nobody's gonna wanna build houses looking at a field goal that emits steam over there or whatever's coming out of there. It's just not gonna happen.
Larry, I know I emailed you on a moratorium, and I don't know what kind of holds that could even do, if it would be applicable.
See, I saw your email before coming here. The tough part is like where our line, it's just like jurisdiction, like anything else. It's just like where that line goes. And that's tough. Now, when you were talking buffer, like, what do you mean by that more
I don't know,
specific?
something reciprocal around that to respect the county line on both sides of the line for each county to be, quote, the good neighbor that we should be doing. Years back, when these large confinement areas were being built, whether they were hog or cattle, people were building these lots and they were kind of doing the same game, avoiding ordinances and weaving through the county lines, and then people were getting too close. Well, finally, the state got involved because they didn't want to have 99 different rules for one thing.
Mm-hmm.
And I just think we should have a buffer out there to protect. We should at least get a right of first refusal on something, okay? That says, hey, being good neighbor, you let us know we really don't want that there. And we can go ahead and proceed with the legal aspect of that.
Yeah, we both look for case law.
And I know there's nothing there.
Nothing there.
And I mean, literally, the Lynn County line from the edge of our city limits on one side of town is less than a half mile.
And here's the tough part with buffer. It's great if Lynn County wants to work with us.
Yeah.
And that's the thing is like,
I don't know if you could just do it so it would at least trigger conversation, because I'm sure the three gentlemen didn't know anything about it, just like we did when the hammer fell. They knew well in advance what was going on in Lynn County, and they failed to do, just being a decent person.
It would be a joint meeting between the two boards even.
I
don't think they'll show up.
No, and I brought an article.
Otherwise, they would have done that before. They've known about this for a very long time. And decided-
Yeah, I brought an article that appeared in the Corridor Business Journal on March 23rd, and I'll leave it with Tracy. But their supervisor, Sandy Sheets, got up and was talking about the power plant, and specifically the ordinance. The ordinance, this is a quote from him. He said, the ordinance does an excellent job of the 2.25 mile setback requirement. Quote, in protecting economic concerns and thinking through what potential community growth, whether it's Fairfax or any other Lynn County city, wants to do in terms of growth, this does a good job of keeping residents' concerns related to property values. I think this is one of the best ordinances, if not the best ordinance our local government in the region has passed to come protecting residents. However, they didn't say boo to Atkins at 1.7 or 1.9 miles from the location of the plant.
Because their focus is protecting Lynn County residents, and that's where they're at. And that's why they're not, meeting with them, I think Tracy's already tried to talk to them, and they got nowhere.
Yeah, we're having the same issue, I mean.
I'm sure you've probably spoken with Damien. Is it Damien, your guys' city attorney?
No, Scott hasn't gotten involved in that until we kind of had this meeting
Yeah.
today to kind of get some views, and now we got a kind of a real clearer path to do things.
Because, I mean, if like he has thoughts or if he sees something where that might be helpful for us, he can always pass on the information. Because
And I know
we
we,
can always miss something.
we engaged Representative Gerhold. It impacts him a lot worse than it does
Yeah,
actually Atkins. He's actually within a 1.5 buffer of the plant.
He lives right there.
Charlie McClintock from Cedar Rapids, we haven't heard much back on that. And I know Tom is busy trying to close up the legislative session down south, and this is on his mind, but it's not the top of his food pile right now, so.
Sorry, I didn't mean to, oh, sorry.
So I personally reached out to everyone from the governor's office all the way down. Tom's the only one that's replied. And I'm putting it on, they're trying to get through this funnel, and Friday night when they all go home, then they'll start working about with their people, is what I'm hoping, because Monday I'm gonna fire it off again. And hopefully someone will respond. But that's on a personal level. It has
No,
nothing to do with that.
I totally understand and appreciate, I know everybody does around the area, but we got a lot of work to do, and like the district attorney said, the utilities board is going to be key to this and getting people to respond appropriately on there so that we at least have their attention.
Well, contact the consumer advocate, because that's they have their duties to the public. That's part of their duties, is to watch out for the public well-being or the public interest. And it's all written out in the code, at least what their duties are, because that's why they're there. They're there to defend the other side, unless there's an intervener.
Also in Huntley, the Sierra Club intervened, so they brought them in. An organization, Landowners Association of Iowa or something. Yeah, so there are other groups out there that you might recruit for help.
And the only other aspect would be the roundhouse area, which falls into the conservation area, where you guys may get involved if we can actually, as the district attorney said, pinpoint pollution or concern to that area's environmental impact.
And the difficulty is getting the studies and the experts.
Yeah, getting it done.
And you're talking
Almost
Money.
six figures.
yeah,
Lots of
your
money.
checkbook out.
Yep.
And we would be the ones that would have to put those studies.
And here's the thing, it would
Yeah,
probably,
it's funny.
because like, even if you intervene, you can even say, I have this interest, that interest, whatever, and the commission board could be like, our legal interest is probably gonna be the only thing we could really talk about, and for us, it'd probably be, what county land do we have owned over there?
They're gonna try to keep the focus narrow because they're gonna get a lot of responses, a lot of people, and so we've gotta control
And
it.
that's why we suggested from the get-go,
It's-
go retain private counsel, because the private individual probably they have more options than we would. Honestly, that's the honest truth.
It would seem that it might be a good thing if we were to direct a letter to the head of this, the private individuals, and possibly the same letter to the city of Atkins and say, this is what we can do. You folks should contact your legal and go down this avenue.
Well, we have to be careful.
If we have to be.
We can't give legal advice.
But I would just ask, because like we did Tuesday at our council meeting, we did pass and have Scott create a letter that was sent, and you've seen it, that it wasn't a resolution, but it was a letter stating that we were not in favor or support the current Alliant natural power gas plant in its current standing to the city of Atkins because of X, Y, Z, whatever. I think the members of or the citizens of Atkins and Benton County as a whole would probably appreciate something similar that you could transmit to the utilities board.
Yeah, and like
And we will when the time
Tom,
comes.
Right, yeah.
like, because we can submit, anybody can submit a complaint or letter, like that's a very well written letter, because like that's something we can always do too, because he can say how you're feeling and stuff too, because he can say, I mean, obviously be respectful, but what your feelings why you're complaining about it, the impact that you're gonna be feeling, and that's different than, say, us getting involved as an intervener, because that's
Where would the state of the federal DOT come in? We know in getting stuff out there, if this was to go through to build this plant, the increased traffic on Highway 30 on and off of that road.
I'm told by Myron that once it's up and running, it's not gonna be that much traffic.
But between now and then, it's a huge safety concern with all the traffic.
And that road sits right on top of the hill there, as the former sheriff knows, and most of the people here. It's already a bad corner anyway. When they go to modify that corner and move telephone poles and whatever else they gotta do to widen it, et cetera, it is gonna be interesting to see how that goes.
Well, and do we have, because I haven't heard, any proposed route for this gas line? Because that could be critical.
I don't think that's been released yet,
Yeah, I don't think so either.
or at least to us.
a little shocker.
I've heard rumors of 50 miles, which puts it at the Marshalltown power plant. So just think of that.
So they're gonna cut
Through there.
across, okay.
Now, to the point of public utility, is there one group that they sell power to that?
That would give them at least an argument it wasn't for personal convenience.
Well,
Yes.
But they sell most of their power to Missouri from around here. If you look at the Alliant postings, half of that goes down towards the St. Louis area, down those power lines. The other third or whatever it's gonna be is most likely can go to the data centers, so.
So we don't know if there would be any released out of that for public use.
There's nothing currently that shows, unless there's other data out there. I haven't seen anything that was gonna be set up for local use.
I mean, it goes into a pool, so
Yeah, and they sell it out of the pod there.
but I don't think the demand for residences and current businesses are there.
If this was just for the data center, we would be on really good footing. So you know they're gonna come in and say, we're gonna sell some of this electricity, help, expand public use. Have to, I mean, it's gotta have some sort of benefit to the public, or else they're not gonna do it.
We haven't had any brownouts, we haven't had any blackouts, we haven't had any shortages of electricity, so what in this equation has changed? This big old building. I mean, otherwise, we don't need a power plant, I mean, they shut down Dwayne Arnold, they're bringing it back up to provide electricity for
It's usually the
Google, they're the ones that are paying the bill.
And here's the other part too, this is a very specialized area
Yeah,
of the law, very complex, and I don't, I mean, don't know all what's the best thing we need report to even ask for, and any of that kind of stuff,
so Alliant is, the reason we're not getting any information out of them is because they don't have to yet.
exactly.
Exactly. They're not going to until they have to.
No, but you know, as I do, that they've been following this playbook everywhere they go.
Yeah.
And they're doing it exactly as they've been told.
Yep. Yep,
So-
all that.
At this point, we wait for the application and then we gear up any way we
To
can.
see what, and like I said, even if we could intervene, we'd likely be limited to what we could even talk about. And that's not fair to give everyone, like, say, sliver of hope that we can argue on their behalf when we legally likely can't.
Ours would be very small.
Correct.
Does anybody know what that window is once they apply?
20 days
How many
Yeah.
days off?
to intervene,
They can start construction once they have,
the approval for you to, from the IUC.
yes, which doesn't mean that they have to have DNR and all of the other permitting agencies out to do that. They just have to be reasonably sure that those permits would be issued, and then they start construction.
Yeah, I saw a case on it, they really raised the issue that, this legal process isn't finalized, and they're already digging, and the court said that's okay. Which I thought was ironic, and
It doesn't make much sense.
No,
But
no.
Well, there's been no environmental groups looking at this data center, because the information's out there, that within a 6-mile radius of that thing, the potential to raise the temperature is 16.4 degrees. Now, on a 100-degree day in the summer, 16.4 degrees that's measurable, and that's big, or in the winter. There's gotta be some sort of an environmental group, I mean, they're all over everywhere. They should be jumping all over this like a chicken on a June bug.
Would that
I
affect
don't get
Benton
it.
County farmland?
in private,
Yeah,
Owners.
Private owners, yeah.
Yes.
and see, that's where it's tough.
Sticky.
Because like we,
What
it's
is,
just, it's frustrating on that front.
what is the name of the 28E agreement that you referred to earlier?
The road one?
Benton Road, I would probably have a copy of that.
Yeah.
There's another 28E agreement from 2016 for the watershed, and we are absolutely included in that.
Mhm. And, which watershed specifically? do you know?
The Middle Cedar,
That's when we were basically doing that when we started, because all the adjoining counties were in that one.
How far away is it from the site? Because I'm not familiar.
the site's all included. I have a copy saved to my phone
Okay.
with a map. I mean, they put a map in there. But it's a huge area.
Mm-hmm, okay.
And they're gonna have to get past the DNR on that issue, for sure.
I'm just saying, we have an agreement with Winter County. I mean, they're on board too, so they have
Oh, so
obligations.
this watershed is with Lynn County as well?
Yes,
It's with like
and it's the
six
city of
counties.
Cedar Rapids.
Yeah.
Can you, let's talk afterwards. Can you, so I can,
I even have all the maps.
I don't think it would affect the WMA.
We're sitting right in the middle of the watershed area. I mean, Grundy's in there, Cedar
Yeah,
Falls is
I
in there.
agree, I'm on that board,
Mhm.
but I'm just thinking the factory itself will not affect it if they build it on the hill. The creek is way to the south.
Well, I mean, any other water is gonna dump into this watershed.
That it gets rid of, yes.
And none of those streams through there are impaired at any level, according to the DNR at the moment.
No.
Fairfax, their most recent city council meeting, they had in their agenda packet, and it was like 400 some pages of stuff, but I popped through there and they had a well study done, and that study is in there, and it shows the impact on the water levels in the aquifers with and without the data center over there. I mean, it does affect the water level, and, you know, water quality. And we wouldn't have to pay for that study. I mean, obviously, it's probably more focused around Fairfax because they have more, you know, well water and stuff there, but yeah, I'd take a look probably.
I'm gonna ask Ray and, sorry.
oh, Derek.
So what value does, submitting an objection on the IUCDF site, what value does that have? Is it,
If it's on infrastructure, or if it's on, if there's some sort of conservation based, and the CSR, you know, those arguments will carry some weight, you know, they will.
And I
It's
think
impossible to
it's,
gauge, though.
I think it's, honestly, if I had to, I hate to say guess, but like, I think it's to also inform the consumer advocate too, of people's concerns and stuff, but I at the same token, that office is meant for the public interest, and I would encourage if you can reach out to the public, or the consumer advocate, and ask what can be done, or reach out what they would like, what would he like to see, you know? That might be more helpful, if that makes sense, because he might be looking at the problem way different than we are, and he might want to say, hey, if you have this sort of so documented, or if you have this sort of information, provide that, you know? Because I mean, that's his job.
So was the county objecting, because you said, obviously everybody knows it's a bad site. The county has reasons why they don't like it. Would that be a good objection where the county could submit that either to Ray or?
We would submit it,
Yeah.
we will, but we
Like
can't tell you the outcome, because we don't know what we're up against yet.
No, but I think it's something.
Yeah, of course it is, and we will.
And it's like something like we can draft a letter, which I, assuming we're probably going to, is like draft a letter, like say complaints, like every other public person.
Yeah,
And just,
objection.
yep. And then, but as far as like when the procedure starts, that's more where I guess we were kind of talking on. It's very tough for the county to probably get into. Like our fight would only be limited to our specific interest that we could have, if that makes sense. Yep.
But Ray, on the disagreement on emissions that this thing's gonna put out, I guess that's where I'm looking to build something on, for the residents of the county. You know, instead of each individual farmer gotta hire an attorney or whatever, I think that's where Benton County, I can't speak for you two guys, but I mean, I feel like I'm responsible, you know, for the well-being and the health of the emissions that this thing's gonna put out for the Benton County residents.
And we'll argue, but they're probably gonna tell us that if we can't show it affects, these residents directly, but, we gotta see what their application says, we know what we can argue, how much and what, but, yeah, I mean, it's not just we're gonna go.
Because the other thing on this deal, it's the same way that Lynn County, with their wisdom, they said 2.25 miles from any town. Okay, Atkins is closer, so does that mean the residents of Benton County are less important than residents in Lynn County?
No, but the ordinance targets a zoned residential area, so that's why it gives them more footing to fight it.
And that again, Tracy, kind of goes to like, it's tough because like our jurisdiction,
I understand the city of Atkins has to have their own attorney, I get that, we don't supersede you guys at all.
No, but like you're saying, there's a 10-mile buffer that's been identified that could have fallout from that, and that impacts Shellsburg, Atkins, Newhall, and places in between.
It's because even if like say a nuisance type lawsuit or whatever, then that's where we were kind of talking about like there's a public and private stuff, both different areas, and that's where like it's essentially going to be expert versus expert, and at that point that would probably be they would be in the position of building it or have built it at this point where we could even have a legal standing to bring such suit. But then here's where the advantage for them is like, well, IUC said we was okay, that we met every standard, and here's the reports and all this kind of stuff. And that's probably honestly the next best lawsuit, but a lot of that can't take place until the thing's up and running. And that's tough.
Yeah.
And
Because
the
our
courts are really reluctant to find a nuisance where the activity is lawfully permitted. So, again, if we lose the IUC, you're not gonna do well in court.
But on the same token, the DNR should have a little bit of pull
Yeah,
on this.
yes, they will.
Because,
Yes.
I can't put a hog confinement up
Right.
on the edge of Atkins.
Right.
I could buy Virgil Krug's farm and put a 10,000, I can't do that.
Right.
DNR would come in and say, forget that guy.
has anybody reached out to DNR?
I have not.
You have not. That might be a good start to see what their thoughts are.
Especially on the watershed issue.
Okay.
Yes.
That's where that's strongest, is through the DNR.
Okay.
But that has to be done as a personal thing, it can't be done as a.
No, the DNR could do it as regulatory.
I mean,
Could the supervisors reach out to the DNR, or does that have to be just on?
well, you guys can reach
Write a
out.
letter, yeah, write a letter to them,
Especially because like if that watershed, I mean, I have to look at the map to even kind of gauge it, you know, because like the whole idea is what's their thoughts, because I know, I think with the Dwayne Arnold, is it Dwayne Arnold? Yeah, I think they got involved in that, right, Ray, or am I mistaken?
Yeah, my understanding is Google is involved with that restoration doing Arnold. I may be wrong on that, but
Because there was a lot of people who intervened in that one, so it's tough to keep track of who got involved. So.
I think we're having a good discussion that everybody knows what we can and can't do.
and we're not saying we won't help, we'll do what we can,
Yeah.
obviously, but we're somewhat handcuffed.
And I will definitely be calling Des Moines to Wallace Building and bending some ears down there.
Yeah, because, I mean, they probably might have a better foot stand too, because, I mean, that's literally all they do.
We used to take care of the livestock ordinance now, and we pretty well,
Take care of, just participate as far as doing the review, but
Yeah.
it's still ultimately DNR decision with all.
right,
And with this, I mean, as long as they're meeting their permits, they're not gonna have a reason to deny them. It's just like with the confined animal feeding operations, as long as you meet the minimums, that's typically gonna be what's gonna issue permit.
okay. Anybody else got anything?
Thank you. Until we know more.
Yeah.
Well, like I said, our-
That's all we can do.
I mean, it's tough because, like, Lion's not helping out the situation, and they're not going to.
No, they're not gonna, they don't have to, it's not happening.
And I don't think our neighbors to the east are gonna be much help either. I mean, I don't think so.
I mean, if I lived in Western Cedar Rapids, I wouldn't be very happy about it.
Oh, absolutely.
Fairfax especially,
Well, yeah, I mean, this one's even closer than the last one.
because the winds are gonna be out of the west more, they're gonna be out of the south.
Well, part of the year it's gonna blow across Fairfax, the other part of the year it's gonna blow across Atkins. I mean, the rain coming in the other day, was it yesterday when it was raining so hard, it came in at a slant from the south.
Okay. Yeah. Good for today.
I think so.
Thanks for accommodating my schedule, I really appreciate it.
Yeah.
All right, Ray. Okay. Yes, I do.
I'll make the motion to adjourn.
Also,
Call for a vote.
Tippit, aye.
See what I.
rules, aye.